Good evening. Welcome to Grace and Gavel, where truth meets compassion. My name is Buffy. I'm an almost 18-year criminal defense attorney. And today we're talking about why is habeas corpus so hard to win, even with new evidence. Imagine being told that the trial is over, the verdict is final, and even if new evidence exists, the system may never look at it. Most people assume that appeals are about innocence, but habeas corpus isn't about retrying a case. It's about something narrower and much harder to prove. The core question: if new evidence suggests a conviction may be wrong, why doesn't the legal system automatically fix it, right? That sounds like a fair question, does it not? Why is habeas corpus considered the last hope, and why does it fail so often? The answer has less to do with truth and more to do with how the law defines error. Appeals versus habeas, the critical distinction. Direct appeals focus on mistakes at trial. For instance, maybe ineffective assistance of counsel, the failure to actually make objections, the inability to provide correct case law. Let's say, for instance, evidence was admitted properly and the attorney didn't object, it comes in. Jury instructions, maybe they were incorrect because your attorney didn't actually look at them and make sure that they were the correct jury instructions. Did the court misapply the law and your attorney did not object to that? Habeas corpus is different. Habeas asks whether a person is being held in violation of the Constitution, and that can be a big bar, right? Can be whether or not your Fifth Amendment rights or your 14th Amendment rights were violated, but that has to be there. And that distinction matters because habeas is not designed to decide guilt or innocence. It is designed to protect the process. To succeed on habeas review, a petitioner typically must show a constitutional violation, most important, that occurred during the original proceedings and that had a substantial and injurious effect on the outcome. New evidence alone is usually not enough. The law is not asking, is this person innocent, right? No, they're asking, was there a constitutional violation that happened, right? That had a substantial and injurious effect on the outcome. Original proceedings. It is asking, did the Constitution fail in a legally significant way? Meaning, did it affect the outcome? Those are very different questions. Is the person innocent versus did the Constitution fail in a legally significant way? A way that potentially injured the person, right? Meaning that they were unable to get a correct verdict that they should have gotten. Now you have the constitutional violation that failed. The Constitution failed them. What counts as new evidence? This is where public understanding often breaks down. Not all evidence qualifies as new. To matter in habeas proceedings, evidence generally must be newly discovered, unavailable at the time of the trial, not merely cumulative, meaning adding on to other evidence that's already available, and strong enough to undermine confidence in the verdict. That's a big one. New witnesses, recantations, or alternative theories often fail this test, not because they're impossible, but because the bar is intentionally high. They do not want to open the floodgates to multiple people seeking habeas issues, right? Because if they do, then that deals with another thing that they're wanting. They're wanting finality of verdict. And if you make the bar lower, more people are going to qualify, which further then erodes their idea of finality of verdict, right? Let's talk about finality versus justice. The legal system values finality. Finality protects stability. It protects judicial resources and the legitimacy of verdicts, which we all want, right? We want things to be final. We don't want to have to continue to drag ourselves to court over and over and over and over again, right? But finality can conflict with the truth, and we see how that could work. We see how someone could be innocent, but they're being denied because they didn't have an issue that fits under the Constitution's failure. That makes sense to us. Once a case is closed, reopening it requires more than doubt. It requires a showing that the system itself broke in a constitutional way, which can be extremely hard to prove, right? That tension between closure and connection is at the heart of habeas law. Let's talk about factual innocence versus legal innocence. This is one of the hardest concepts for people to accept. Factual innocence means a person did not commit the crime. Legal innocence means the conviction cannot stand under the law. Habeas relief focuses on legal innocence, not factual innocence. That means someone can present compelling evidence of innocence or that they're not guilty and still lose a habeas petition if the constitutional requirements are not met. That is the biggest hurdle that they have. So why does habeas still matter? Despite how difficult it is to win, habeas corpus matters deeply. It exists as a safeguard, a reminder that no conviction is beyond scrutiny, which sounds great in theory, right? Until you realize that it is a high bar when constitutional rights are violated. Its rarity does not mean it is meaningless. It means the system is cautious, sometimes too cautious, about reopening the past. The takeaway? Habeas corpus does not exist to guarantee perfect outcomes. Humans are involved, so of course nothing is going to be perfect. It exists to prevent unlawful detention, and that narrow purpose explains both its power and its limitations. So in closing, when people ask why new evidence doesn't automatically overturn a conviction, the answer is this: because habeas corpus is not a retrial of the facts, right? The original trial court is the trier of fact. They're able to see the witnesses. They're able to see the evidence, so they know what's actually going on. When you're going into appeals and you're going into potentially looking at overturning a verdict, those people do not see the original witnesses. They're reading a transcript. And a lot can be lost on reading a transcript, right? You don't know the mannerisms you don't know the mannerisms of the witness. You don't know whether or not they were credible. Ultimately, you have to judge based on what the trial court found. And that's why they get a lot of discretion, because they were there when the witnesses were testifying, when evidence was presented, and actually presided over that trial, right? It is a constitutional checkpoint. And passing through that checkpoint is one of the hardest things that the law allows. Thank you for tuning in to Grace and Gavel, where truth meets compassion. And I hope that you have a great day. And I appreciate each and every one of you tuning in. It means a lot to me. And if you have some story ideas you're interested in, feel free to drop them in the comments in the community. As you know, I'm involved in the community and I do often comment. And feel free to shoot me a message if you like. Have a great day. Bye-bye.